As Michael already said, I gave my talk, the title, The Rule of Law as a Pragmatic Ideal. The background of this is a little bit that in this paper I'm trying to bring together two parts of my thinking. I'm a professor of jurisprudence, so I have a background in philosophy and law. And that means that I've done standard legal philosophy work on conceptions of law and tried to develop a theory of that. Of course, that's what philosophers love to do. But I also more specifically work on a project, a little bit like this seminar series, a project on the rule of law. And the idea of that project is to make a link between normative approaches to the rule of law, so the rule of law as a central value of law or politics, what have you, and functional approaches to the rule of law. So the idea that the rule of law is good for something else, and that we need to look at it functionally. In this, as I said in this talk, I will bring together this more theoretical perspective with that rule of law thinking. I've decided not to use a PowerPoint, so if you start to look really puzzled and worried, then I'll take that as a cue that it's not clear, but I hope that won't be necessary. But, in the context of legal education, I think we should discuss the role of PowerPoints, but not in the context of this lecture. So, the starting question is, how do we justify the rule of law? For some people, that's a question that really doesn't matter, right? The rule of law is self-evident. It's the central value of any self-respecting legal system, you might say, or you might even say that its meaning is no more than the government of law, not of men. And that it's an easy argument and also easily satisfied. But sometimes I imagine that I'm sitting face to face with some skeptical politician who actually doesn't believe in the rule of law. And I think you can all picture a world leader or a couple of world leaders at the moment that would fit this bill. And that I have to convince that person that the rule of law is actually an ideal of the law that ought to be respected. Not only by those who apply the rules, such as judges, or those who are subject to the rules, such as citizens, but also by the ones who make the rules and who determine what the law is. And that is actually not always so easy. In that imaginary debate with the politician, I find myself wanting to make two types of arguments. On the one hand, I want to explain why the rule of law is a central legal ideal by referring to a broader theory of what law is about and the concept of law itself. And on the other hand, I also want to defend a particular vision of the rule of law, of what it is and what the values of the rule of law are, and that probably will not be acceptable to everyone. What I worry about in this still imaginary conversation with the politician is the argument that the rule of law is fine for the ordinary everyday legal problems, but that it is not absolute, that there may be reasons to limit the rule of law, and that reasons to do so are the public interest or the common good, of course, to be determined by this politician himself. Just last week we had a seminar in Rotterdam, and that was given by a colleague of mine, Jean Gakir, who's a professor of law and literature, and we discussed a play. Some of you may know it. It's the play Terror by Ferdinand von Schirach, a German play. I see some people nodding, that's good. And it's a very interesting case where a fighter pilot shoots down a passenger plane that has been kidnapped, hijacked by a terrorist, and the terrorist is threatening to fly the plane or force the pilots to fly the plane into a stadium full of people. And the fighter pilot shoots down the plane so that the people in the stadium are saved. The play is actually about the court case in which this fighter pilot is on trial for murder. And the audience is actually asked to give the verdict in the trial. An important element in the play is the judgment by the German Constitutional Court, the actual judgment that they gave, that a law permitting such an Air Force action as shooting down this plane is unconstitutional. From a rule of law perspective, the court said this cannot be done. And I think you might say that this is in a way, reassuring judgments that it's not up to the president or the minister of defense to actually determine when to kill innocent people for the greater good. However, there are many people, and this is actually shown when you look at the statistics from how people voted in the verdict in all those theaters. There's a common sense intuition that sometimes such actions are necessary, and that the rule of law sometimes needs to be limited or curtailed to avert a great danger to society as a whole. One reason why this argument worries me so much is because I actually defend a pragmatist theory of law. And I don't know if you're familiar with the philosophy of pragmatism. I can imagine that some of you are not. This is a branch of philosophy that sees truth as something that works, so that has practical consequences. And it actually calls on scientists to judge propositions by the consequences of those propositions and not so much by their fit with unchanging principles. Pragmatism also says that judgments are provisional and open to revision if new knowledge comes to light. And then you might ask, where's the space for a firm or principled defense of the rule of law within that theory? So how can a pragmatist answer the case of the hijacked plane in favor of the rule of law? Shouldn't the pragmatist simply say, well, you know, exceptional situation, if you look at all the consequences, this is better? I don't want to say that, but I have, but sort of the task I've set myself is to argue in a pragmatist way for a strong idea of the rule of law. So the question I have for this paper is what ideal of the rule of law can be defended pragmatically, and how can that ideal of the rule of law be supported by a theory of what law is? Now, within legal philosophy, that means I take my cue from a colleague, and actually I think he's a New Zealand colleague, but he works in the United States, Jeremy Waldron, who claims that legal philosophers need to connect their thinking about the concept of law to their thinking about the rule of law, and that the concept and the rule of law are mutually influential ideas, and that a lot of philosophers pretend as if they're not. And I've never actually tried to do this, these two sides of my own thinking, so that's what I'm doing today. And the thesis I want to defend in this paper is that a strong normative ideal of the rule of law is necessary to make law function well, for the benefit of people who make, use, and are affected by law, so people like you and me. Now, there are some underlying intuitions in formulating this hypothesis which have to do with this pragmatist thought. Basically, my idea is that in order to make law function, its core needs to be non-functional. So there's a sort of tension, or maybe, well, paradox is a bit too strong a word, tension at the core of law. And this has to do with a particular view of what works in a pragmatist theory. And pragmatist theories are about solving actual problems that people experience. So not theoretical problems that we simply imagine, but problems that are in people's real lives. However, it's important to realize that a pragmatist theory doesn't say that whatever people experience as a problem, that's what we're going to solve. They also look critically at those experiences. Is this a real problem or not? And what's also important to note is that pragmatist theory starts from an idea of a certain modesty of what science and theory can do. Your assessments are provisional, they're temporary, and your solutions are tentative. You try some things out, but you don't claim that they're good for forever. Furthermore, and we'll come back to this, it's strongly contextual, so the context in which problems are experienced matters, not only to understand why they are experienced as such, but also to see whether solutions might work, and that will be we will return to. And for this, both factual perspectives and evaluative or normative perspectives are necessary. So we need to relate the rule of law to the social, political, cultural, and historical circumstances, But we also need to relate it to other values and to think how it matters for that. I'm going to do the rest of this paper in, if I'm counting correctly, four steps. The first step is to show what this pragmatist conception of law is. Law is interactional and value-laden. The second step is to argue for certain specific values of legality or the rule of law, where I construct a partly procedural and partly substantive set of principles as the core of the rule of law. The third step will then be to connect that idea of the rule of law to a functional and contextual argument about the way pursuing the rule of law can be justified as contributing to broader purposes. And the fourth step is actually to try to show how this works by way of an example, which I take from Dutch law. Okay, let's move to that first theoretical step, a pragmatist conception of law. If you start to think about law and the rule of law as a combination of ideas, as Waldron urges us to do, it seems that the crucial starting point is the link between the two. And you could say that law is widely understood as a part of social reality, and that the rule of law is a value or an ideal. So the way to link these is actually to see law as a part of social reality that is oriented towards a certain ideal of the rule of law. There's an American legal sociologist that's not very well known. He's called Philip Selznick, and he actually developed this idea in his work in the 1960s and 1970s. And he sees law as what he calls a normative system that is oriented towards the master ideal of legality or the rule of law. I think this is a good starting point, but it needs some development as a theory of law. And I've argued also previously in other work that you need to look for that support in pragmatist philosophy. And the most important elaboration that you need is to get a sense of what law might be. Law as this normative system oriented towards ideals, what is that? I think it's more usefully described actually as a practice rather than as a normative system. I'm a little bit allergic to the term system. It can mean lots of different things in different contexts. And how I understand practice is as a sustained way of doing things together, so it's a social action, and that's oriented towards a purpose or a set of purposes. So it's not action just randomly doing things, but oriented towards to achieve something. And if we see law as a practice, you could see it as made up of the interactions that people have with each other. Interactions which are shaped by the expectations that we have of how people behave, so factually, but also how people ought to behave, so our normative expectations of each other. This account of law as a practice also builds on the work of another legal thinker, and that's the legal philosopher Lon Fuller, who defends a theory of interactional law. And Fuller actually says that law as we know it takes different forms. The two basic ones being enacted law, as he calls it, on the one hand, and the other one being interactional law. The second, interactional law, is made, as I've just explained, between the participants in practices, and has a horizontal orientation. So it shapes the expectations and actions of people towards each other. While enacted law is made law, so law that is invented in some way, coming from an authoritative source, for instance the legislature making laws, and that has a vertical orientation, so it links a ruler or the maker of the rules to those who are ruled by the rules. Now, Fuller's writings on enacted law have been quite developed, mostly in his book, The Morality of Law, which is also quite well known. And unfortunately, his theory of interactional law is scattered through a number of papers, which have been collected in a volume, The Principles of Social Order, but he didn't do that himself. Another theorist, Ken Winston, did that, and it's not quite as as uniform part of his theory. But it is important to note, even if you read his work on enacted law carefully, that it's all underpinned by an understanding of an interactionist account of how law works. Law is a relational activity, whether it's enacted law or whether it's interactional law. It's about shaping the expectations of others, and even an enacted rule needs to be used in horizontal interactions between people themselves. My favorite examples to illustrate this are actually from traffic law. Now, it's very different here in Poland. I don't see any bicycles here, but in the Netherlands, as you know, we have loads of bicycles. We have a traffic rule, both for cars and bikes, is that all traffic coming from the right has right of way over the traffic on the street that you're on. So if somebody comes to the right, you have to stop and give right of way. However, in the city where I live, and I think it's the same in other cities in the Netherlands, this rule is not a very clear one. Both cars and bicycles, mainly the bicycles actually, usually take right of way when they're on the bigger street rather than on the smaller street. So although we have a formal rule that there's right of way from the right, in practice that's not really the rule that you work with. You would be a little bit suicidal if you would take your right of way from the side streets if you're going onto a bigger road. And sometimes you even see that on dangerous crossings it used to be like that, but then they changed the rules so that the bigger street actually gets right of way, sort of to conform to what happens in practice. I think that is the point of such an example, is that enacted rules actually need support in action in these horizontal interactions between people. And if their interactions and expectations start to differ from the enacted rules, then you might ask whether that enacted rule still has validity. Now, you might stop me here and say, well, this is all very well, this interactional account, but you started to talk about a value-oriented practice of law. How does this link to each other? And my answer would be that these interactional practices of activities and expectations are actually shaped by the central values that belong to these practices. You could look at this from an outsider's point of view, and you could say that law is oriented to the value of legality, that you could describe it like that. But more importantly, I think the participants in these practices use these values to shape their interactions. And I think that the central values of a practice are actually a major element to distinguish one practice from another. So, for instance, it would be very strange to say that the practice of education, like in a university, or the practice of making arts, are shaped by orientation towards an ideal of justice or legality. That would be strange, right? Education has another purpose and another central ideal. But for law, it does make sense. So you could, I think, define the practice of law by trying to figure out what ideals it's oriented towards. And according to the thinkers I use, Selznick and Fuller, it's the ideal of legality or the rule of law that actually defines that central purpose of the law. I've thought about this, and I think it's not quite complete. Legality alone, or the rule of law alone, which is, according to especially Selznick but also others, centered on non-arbitrariness, and I'll explain that later, is not really enough to understand what the practice of law is about, what we expect from it. I think at the very least, we also need an idea of justice. And then we need to think about the meaning of such an ideal for the practice of law. Is justice mainly about formal equality, treating like cases alike, as they say, or is there more to it? And to flesh this out a little bit, I draw on a different tradition of thought, actually German legal philosophy, where my favorite is Gustav Radbuch, whom you probably also know, to argue that if you see law as distinguished by an orientation towards justice as formal equality, as Radbuch also says, then that value needs to be given content. You cannot simply say, well, that's all there is to it. You also need to know what counts as equal, under what circumstances, what needs to be treated equally. So even more than legality, I think justice shows that although we have distinctive values of law, values that fit law much better than other practices, you cannot understand these values without understanding how they link to other broader social and political values. Now, if you follow my reasoning here, that legality as non-arbitrariness, or other people say legal certainty, and we'll get to that definition, and justice, so the two of them are central values of law. The question, of course, is also how they relate. On the one hand, you could say that legality, as being calling for non-arbitrariness and legal certainty, also contains an element of justice in it. You know, treating people equally is also something that comes across as non-arbitrary. So a substantive interpretation of what is non-arbitrary has clear overtones of justice. On the other hand, you can also see that there is a tension between the two of them. And that tension was very central to Erasmus thought, who actually thought that sometimes you have to make a decision on the basis of legal certainty. He was more in favor of legal certainty and legality. And that might actually leave you with a feeling of injustice. And there are other thinkers, also ones that are sympathetic to pragmatism, like the realist Carl Llewellyn, who also thought about this as a conflicting demand between law or rule of law and justice. So we can understand the rule of law as the value that calls for certainty and regularity, and justice as demanding equality in a more substantive way. Now, if you see these values as connected but also potentially conflicting, I think they give practices of law also an element of plurality. And where I started speaking about the practice of law as following Selznick, who says law is a normative system, I now tend to think about it as practices of law in the plural. Because I think you can use the central values of law as the marks of what is distinctively legal, as Selznick says, but I don't believe we can see law as one grand unified practice. There are multiple practices of law, both, well, the different legal systems that we know, but also within those different legal systems or states. And of course also beyond them in the form of international law and transnational law. And in all of these, I think the values of law are relevant, but in different ways, and the relationship between them may also be different. Now, for now, I think it's sufficient to state that plurality of legal practices and within legal practices can arise in the form of a tension between these legal values, that they point in different directions, but also as different interpretations of a practice by the people in it, and the norms and values that, how they interpret the norms and values that are part of it. And these norms and values will refer to legal, central legal ideals, but they're also shaped by other purposes and other values in society. And we'll get to that point, how rule of law relates to other concerns a little bit later. This first, before I go into that, I want to discuss a little bit more at length what I think the values of the rule of law are. I've thrown in non-arbitrariness, legal certainty, and you've probably wondered, well, you've not really explained it. That's true. And I think more needs to be said about what that value of the rule of law itself is. A lot of rule of law scholars have a debate about the rule of law in terms of formal versus substantive theories of the rule of law. I'm not going to rehearse that debate. There are books about it. My starting point is actually theory of one of the people I already mentioned, Selznick, seeing the rule of law as the central governing idea for the practices of law. And in that role, I think his definition is worth quoting in full. As Selznick says, legality is the following, and I quote, "The idea that a legal order faithful to itself seeks progressively to reduce the degree of arbitrariness in positive law and its administration." And Selznick then explains that it's not the aim of this ideal to protect the individual against all power, but only against the misuse of power by those whose actions have the color of authority. So I think that's a good starting point. But what is this value of legality then? So the progressive reduction of arbitrariness in positive law and its administration. Sostek himself, when he explains it, actually directly links it to ideas of justice, as we've described, emphasizing that it goes beyond formal justice, and also to democracy as a form of critical participation by citizens. And I think it's useful to see these links, but I think first we should get clearer what legality itself requires. So you need to specify a little bit further what non-arbitrariness means for the practices of law. And I think it's useful here to link to some elements that I think are present in that practice. And if you think about it this way, I think it's possible to specify 4 constitutive values of legality. So we have the ideal of legality, and there are 4 parts to that. And I'd be interested to hear later if you agree with that analysis. I think an important part of law is that it has a culture of argument, I would say. It's about language, debate, trying to convince people of a certain point of view. And as an argumentative practice, I think non-arbitrariness calls for the rationality of decision making. You don't simply, take a decision and dump it in the middle of the practice you want to regulate. You have to explain why it's a good decision. You have to justify it. And I think as lawyers we take a lot of time doing that. And I think reason as opposed to power requires decisions are made that can be justified according to the norms current in a certain practice. So that's the first element. The second value links to the use of rules, because I haven't mentioned that, but even in this interactional practice-oriented view, rules as concrete norms of conduct are very important. And this value then states that the application of rules needs to be predictable. I think this is the most common elements of non-arbitrariness that we're used to as lawyers. But there are 2 more. The third value, I think, links to deciding concrete cases, also something that's very crucial in law. Whether it's by the administration taking a decision or by a judge adjudicating a case. And that third value demands fairness in the individual case. So a fair decision that does justice to the different interests at stake. The fourth value then concerns accountability to affected individuals, which not just links to the rationality of decision making, explaining yourself, but also includes participation in the form of being able to advance arguments or to complain about a decision. So it actually says that there needs to be a role for those affected. Now, why do I highlight these 4 aspects? I think none of them are new. I'm not being original here. But they're actually not so often part of the standard sets of rule of law values that are rehearsed in the literature, which focus on clarity and non-retroactivity, etc. And the unifying trait, I think, is that they're all 4 counterparts to the simple exercise of someone's will without any further explanation. So if somebody claims authority over an individual or practice, it's possible for that person to claim respect for their decisions. However, the participants in such a practice, the persons having to deal with that decision, will see it as contrary to legality if it's simply an exercise of willpower. And I think there are at least these 4 ways that I've just sketched in which we can say that a decision can be in accordance with legality. By rational justification, by being the predictable application of a rule, by being fair, or by being accountable to the persons affected, by giving them a voice in the process. Now, sometimes these values may clash, and sometimes they may reinforce each other. And in that sense, the rule of law values themselves are plural, making the ideal actually a complex ideal. Now here you may become a little bit puzzled, because I've already talked about different central ideals of the practice of law that can be in tension, and now I'm unpacking one of those ideals again as 4 values that are in tension. And you might ask, well, what kind of standard is the rule of law then? How can we judge actual practices of law? And I think that the plurality of practices of law that we can see in social reality is not easily judged by one universal standard. I don't really believe in that. I think that the ideals of rule of law and justice, provide distinctively legal orientations. We can recognize them across legal systems, but you need to apply them in a certain context, and then they become a little bit variable. And I think we should acknowledge that there are numerous practices that can serve the rule of law in a meaningful way. There's not one size fits all. And that there are at least as many practices that can fall seriously short of the rule of law. So while the overarching idea of non-arbitrariness is relevant in all legal practices, the precise contribution of various elements, the relative meaning of the rule of law, needs to be judged contextually. Now here, I think the pragmatist interactional theory provides a useful underpinning to understand what this means. A crucial element of pragmatist thinking is that these practices and their guiding values form responses to experienced problems. I said that at the very beginning. For instance, think of a highly bureaucratic legal culture. I think of the culture in my own university, for instance. Their non-arbitrariness usually takes the form of predictable rule application. We have loads of rules, and the officials of the system apply them. However, such predictable rule application may very easily give rise to growing problems in other parts of what we think is non-arbitrary. For instance, the fairness of decisions or the accountability to those who are affected. And one example that I was thinking of is actually currently a problem that lawyers in the Netherlands worry about, and it concerns our tax system. The Dutch fiscal system is a highly routine system with lots of automated decisions, and the programs to fill in your tax forms are all digitally pre-formatted, etc. But if you have received a tax reduction because you've made, for instance, a mistake, you thought you were entitled to certain childcare benefits, but you're not, and your application turns out to be against the rules, you need to pay back immediately. And if you don't pay up, you will be fined. And if you don't pay your fine, that fine will be doubled. And this all happens in an automatic way. And what's now become apparent is that the Dutch tax authority is one of the biggest sort of creditors of debt for poor people in the Netherlands. So they don't own debts to private company, they own debts to the Dutch state. And this is because this is this automated system. And a lot of people who are, are poor, have low incomes, limited knowledges of the system, don't open their mail, and then this runs up, right? So the Dutch ombudsman has actually complained about this, and it says it has really unfair consequences because people are hardest hit who can actually not afford to be hard hit by the Dutch government. And I think what such an example shows is that emphasis of one partial value of the rule of law, predictability, which is highly predictable, can seriously go wrong if you judge it by another perspective, in this case the fairness of decisions. Now of course that's a familiar tension in law, formal decision making versus fairness in the individual case. But I think it does show that you always need to watch out for new concrete problems that may arise when you sort of set up a system of rules. And that these problems can arise because of this plural orientation of the rule of law that I've just sketched. So I tend to think of it as a dynamic practical experience. Once we observe a certain problem with the rule of law, we may use the rule of law ideal to counter that problem. However, in the process, it's highly likely that another aspect of the rule of law over time gets overlooked. And once you notice that, you may again change the practice, and the balance may tip towards the other end of the spectrum. And I think it's very unlikely that we ever reach a stable equilibrium. So I don't believe in sort of idealized rule of law state where everything is well. It will be continuously changing. Now, a final point I want to make about the values of the rule of law is about the specific relationship between rule of law as non-arbitrariness and legal institutions. And by this I mean the organizations that we recognize as having the authority to make and administer enacted law, like legislatures, courts, etc. In order to make these ideals of rationality, predictability, fairness, accountability work, I think it's necessary to have a sense of the institutional conditions under which they are to be applied. You cannot do without a look at the institutions actually responsible for this. And I think this leads to an idea of a balance of powers. And that cannot, I think, be directly derived from the rule of law ideal that I've just sketched of a reduction of arbitrariness, but it's a crucial condition to make non-arbitrariness possible. I think balance of powers, which introduces the familiar idea, at least in continental Europe, familiar, of trias politica, Montesquieu's idea, says that concentration of power is problematic because regardless of what institution is concerned, it creates opportunities for arbitrariness. If you hold all the power, if you don't have to explain yourself to others, it's very easy to abuse that power. So I think that's sort of the insight behind that. So the underlying thought for linking balance of powers to a rule of law ideal is that the plurality of institutions who wield authority and thereby have the power to influence or determine the position of others will limit the opportunities for one institution to act arbitrarily or willfully, because others will demand justification. So we keep watch over each other, so to speak. And I think the culture of arguments that I've mentioned that is so important for legal practice actually demands a debate between these different actors and a sense that these various actors need to justify their actions to others. That also means that conditions of plurality and openness towards other actors are important to realize this rule of law ideal. You need a sense of plurality and this interaction between different actors talking to each other. Unfortunately, it also shows that the practice of law, as serving the rule of law, is at risk when certain actors start to dominate and frustrate such plurality and openness. So it's a very normative vision, and I'm fully aware of that in the reality of today. It's not realized everywhere. So there's a dependence here on what actors within a practice actually do. The value orientation of a practice can only be realized if it is turned into action by participants in the practice. Okay. The third step I wanted to take was to place this in a broader context and give a functional argument. So here the idea is that we need to argue why the core values of the rule of law are the ones that must be upheld. Now there are different ways of doing this. You could have a natural law theory deriving from first principles, or the complete opposites, starting from what people in society actually think the rule of law means. I don't want to do either. As well, you will have guessed by now, I want a pragmatist argument for this. And that means asking why rule of law values work, in the sense that pragmatism means how values could work. We'll get to that. So a functional argument for rule of law values. Now, traditionally, functional arguments have in common a focus on mechanisms that ensure that a certain entity continues to exist and to flourish. Functionalist theory of law sees law as a mechanism that ensures the thriving of society or the maintenance of social order, and a lot of sociological theories make functional arguments about law. And although my question here is about the rule of law, the functional argument for what the rule of law might mean, it makes sense to position this question also in relation to functional arguments about law in general. And in most functional accounts of law, the argument is interpreted narrowly or specifically. People try to see law as having a specific function that sets it apart from other institutions. And actually a similar strategy is taken by our colleague Martin Krieger, who gives a teleological account of the rule of law, who also tries to argue that there's something very specific about this, carefully restricting the rule of law idea to limiting arbitrary exercise of power. So law and the rule of law here have a the specific function that sets them apart from other social institutions and from other values, depending on what you're looking at. I think that from a pragmatist perspective, this is not very plausible, because in those accounts, the emphasis is on figuring out what sets law or the rule of law apart, and it misses the point of a pragmatist assessment, which is to consider it in relation to the conditions and consequences that a problem or an idea has. And I think it's highly plausible, as some have argued, that other social mechanisms than law also provide order. You could think of lots of social institutions that do the same. But that doesn't make it a stupid idea to look at the function of law, even if that function is shared by other institutions. So although the rule of law may be best captured by the value of limiting the arbitrary exercise of power, it is important to ask what achievement of that brings in terms of the broader social and moral purposes and values. And I think it's important to ask these broader questions, because you can't simply assume that achievement of rule of law ideals is always for the larger good. That's what I started with, right? To have a skeptical politician as my discussion partner who doesn't believe in this. So I need to argue that. I do believe it, but you need to counter these claims. So in terms of the arguments of the previous section, it depends on the context which constellation of rule of law values will work best. And that brings to the fore the pragmatist method of justifying a certain value, which asks under what conditions and with what consequences that value may work. And the embedding of this argument is actually in a broader view of science that I derive from pragmatism. This is John Dewey's work, classical pragmatist, the early 20th century. And what's key to Dewey's pragmatist theory is that values are subjected to the same experimental reasoning that he also applies to scientific propositions. So whether it's physics or morals, we can all, apply the same method to them. I always thought this was a really nice idea, as one we still don't quite believe, most of us. So if you apply this to values, you must say that before we accept a value as a standard to be upheld, we need to examine under what conditions it can arise and what consequences its adoption has. So you actually don't simply accept a value as something that's good. It must be regarded as a hypothesis to be tested, and to be tested in terms of its imagined consequences. And I think we can say that this is a normative version of the functional argument that I used earlier, that actually explains why law can maintain social order. This kind of argument doesn't explain, it justifies the value on the basis of its consequences. Now, I'm very much aware that for some, if you look at this from a moral point of view, it seems a dangerous route to take. Doesn't that mean, if you judge a value by its consequences, that you actually subordinate the value to the realization of certain other things? And wasn't that what you didn't want to do, right? So doesn't this mean a reduction of a value to a means rather than seeing it as an end in itself, to use Dewey's terminology? I don't have time to go into that point at length. I've argued it elsewhere, but the whole point of the pragmatist imaginative exercise is to examine conditions and consequences as a holistic idea. So you don't single out certain consequences that you want to consider. No, you have to look at the whole range, also the ones that you didn't expect or that may be unfavorable, and you have to weigh them. So it's not just one kind of consequence that matters. For instance, the final result, saving the lives in the example of shooting down the plane. But you also need to consider what the consequences are for the status of the means themselves. And in our context, what does it mean for upholding, for instance, ideals of human dignity or the rule of law? And it also, and this includes thinking about the integrity of the legal practice itself as one of the consequences. Of course, it cannot be all. It's a broader vision, but it's part of what you need to consider. Now, a limiting aspect, I think, of the pragmatist methodology to look at the rule of law functionally is that it cannot really be done at the high level of generality that I'm now speaking of. And this is because it's a problem-based method. There needs to be some actual problem about the rule of law in order to think about what the conditions and consequences are. Problems arise in specific contexts. They don't turn up out of the blue. And these contextual conditions need to be considered and examined in order to make a plausible argument about the role of the rule of law. So then the varieties of the rule of law in context start to matter, so that the argument to be made is one for a specific constellation of rule of law values in light of the specific social conditions and consequences. Now the problem is that, of course, I'm a philosopher and a theorist, so I don't really know much about these particular conditions. I find myself always a little bit advocating this really contextual and embedded argument about the rule of law, only to say, well, that's where my knowledge ends. So these theoretical tools of mine can do certain things but not others. And in the next section, in the final part, 5 minutes or so of the talk, I will attempt to illustrate this with an example that I do know. But here I want to focus on a few general connections on this theoretical level that I think can be made between the rule of law and other values. And I've been pressed by some colleagues who wanted me to flesh out what that then means, this pragmatist perspective for the rule of law. Now, at the beginning, I emphasized the role of practices and interactions for a pragmatist theory of law. And this was an explanation how I think law should be understood, but I think it has normative implications that are important. A crucial aspect of pragmatist interactionism is the role of individual people in making law. It's not just about enacted law, about a ruler making rules for the citizens. It's also about citizens and people themselves being involved in the making and changing of law. And if you believe that, as I do, this has a number of normative consequences for how the rule of law links to these people, these individuals. For instance, first of all, it entails respect for the individual as an actor and recognition of basic rights. Now, to sum this up quickly, the background of this is that it's mainly that individuals must be capable of fulfilling their role in legal practices in a meaningful way, and they need certain tools and characteristics for that. And they must be able to put law to good use for the purposes that they have. Well, you could make an argument for education. I think that would also be something that Dewey would do. But as Amartya Sen has argued in relation to development, it means that certain conditions need to be met in order to enable individuals to realize their capabilities, as Sen calls it. And the idea here is that things like hunger or illiteracy can actually prevent people from using their capacity to think and be creative. That means that you can make an argument for basic rights, not just civil and political, but also socio-economic rights. So that's the first point. Second point is that individuals need to be able to take part in legal processes. This is a point I take from Jeremy Waldron, who says that the rule of law is procedural, and that people need to be given a voice in the legal system when it comes to decisions that directly affect them. That's crucial for the rule of law. And I would add to this that it's not just a rule of law requirement of non-arbitrariness, it's also a matter of acknowledging the creative role of individuals when it comes to shaping legal practice. If you take seriously this idea that individuals take part in making the law, well then there needs to be space for that. So normatively, I think a pragmatist should say we need to make that space for individual contributions. And then I think this can counteract sort of the idea of interactionism that has a slight tendency to be overly focused on the social relations and what we do together as a group. And I think the nice thing about pragmatism is that it doesn't just look at the social, it also looks at the role of the individual. And if you look at the way individual people may have a special role in shaping the system, you can actually look for the individuals that matter, the creative individuals that have made a difference. And I think, for instance, of creative judges, my favorite examples are English judges, such as Lord Denning. If you've never read a verdict by him, please do so. They're lots of fun. But it may also be individual citizens who criticize and test existing legal practices. And there may be also groups or organizations who do so, such as NGOs that push for change. And in my example, I will highlight one. And in order to make possible that individuals put their mind to work, to use their creativity, I think it's necessary that there is space for that input. This is not just a matter of procedural rights, right to be heard, but also, I think, a recognition of individuals as worthy of respect, as worthy of being listened to. And that means, I think, in the abstract, that a crucial function of the rule of law is to ensure that legal practices show respect for individuals and their rights, that they're open to participation and criticism, both by individuals and groups. And therefore it makes sense to link the rule of law to basic human rights and to democracy. Not a very surprising conclusion, but still, I think it's important to make the argument. Now, this is where I leave it as a general discussion, and I think I have about 5 or 6 minutes left to present an example that I think can show this interaction of different considerations that are relevant to the rule of law. I will focus on a recent Dutch case which caused quite a stir in the Netherlands, and it was mainly because of what the court said about the rule of law, and a lot of lawyers worried about that. It's a case by the District Court of The Hague, so that's the lowest layer in the court system, from 2015. It's the only actually first instance case that I know of that was translated into English, which was so the court already knew that this was going to be high profile. And it's known by the name of its claimant, Urgenda. And Urgenda is an NGO which is devoted to action to protect the environment, and more particularly to combat climate change. And in this case it filed a claim against the Dutch state for failing to live up to its climate change commitments. And it's an interesting judgment, both in terms of the legal argumentation and in terms of the view it expresses about the balance of powers between the court and government, and it drew quite some criticism because of that. The background of the case is as follows. This will be familiar to you, to many of you, I think. There are, of course, all these international climate change discussions, policy discussions, in which the Netherlands participates, and we negotiate the treaties, etc. And it promised to do its part in reducing CO2 emissions, important to combat climate change. And in Europe, this is also supported by the Treaty of the EU and a number of regulations by the EU. So there are goals of reduction that have been set. And what Urgenda did in this case was to claim that the Dutch state does not do enough to reduce CO2, and that it will not succeed in achieving the target reduction. And it claims that the state therefore fails in the duty the state has to care for the environment. So the legal structure is that the claim is actually a private law claim about the duty of care. And the legal question is whether this claim by Urgenda is legally enforceable. Does the state indeed have a legal duty of care for the climate? And does that entail that the state should reduce its emissions of CO2 by 25 to 40%? Because this is what Urgenda claims, that the court should actually order the states to reduce emissions by 25 to 40%. Now, it was a complex question, and it's a really lengthy judgment with bringing in international expertise on scenarios about necessary reductions, legal documents, policy documents, international, European, national, etc. And what's striking about the decision is actually that the court focuses on the question what the policy goal of the government should be. And in a number of passages, the court points out the severe consequences of climate change, the highly hazardous situation that will occur if reduction goals are not met. And the core claim here is that the prevention of dangerous climate change calls for a reduction target of 25 to 40% in 2020. So we're already very close to that. And this argument is connected to the legal duty of care as developed in tort law. And the court actually rules that the state must take more action to reduce greenhouse gas emissions in the Netherlands, and it has to ensure that the Dutch emissions in the year 2020 will be at least 25% lower than in 1990. So the consequences of not taking enough action are reason here for the court to order the state to return to its earlier policy objective that they are no longer realizing. Now, why is this a striking or maybe even problematic decision from the point of view of the rule of law? Of course, the main issue here is that the court doesn't actually take a legal decision, it takes a position on a policy question. A question many people believe should be answered by the government and not by a court. So the problem is with the trias politica, or the balance of powers. And the court itself realizes this, and as a sort of afterthought, after this lengthy judgment, they have a page or two also about the balance of powers and the rule of law. And then you realize that the court doesn't think it's very problematic at all. It says that it realizes that this decision will have broad consequences for other parties than the two involved. And now I'm quoting, "This prompts the court to exercise restraint in allowing such claims, all the more if the court does not have a clear picture of the magnitude and meaning of these consequences." So you think, oh, well, that's, it's a sensible court, restraint. But then it goes on. It stresses that its task in a rule of law context is also to counter government action. And I quote again, "The task of providing legal protection from government authorities, such as the state, preeminently belongs to the domain of the judge. The possibility, and in this case even certainty, that the issue is also and mainly the subject of political decision-making is no reason for curbing the judge in his task and authority to settle disputes." So the court sets it up as a conflict between judicial restraint, sometimes necessary, but providing legal protection, more necessary, and in this case it therefore chooses to provide legal protection, not actually paying attention to where that balance should be. Now, how may the theory of the rule of law that I advanced before frame or understand such a decision? The first thing to note about the case, which is exciting, I think, is the role of the different actors involved. I've quoted from the judgment of the court, but the case is, of course, not only about judiciary versus government. There's a civil society organization behind this. They've pushed for this, and they were actually smart enough to think, well, we now have a chance that this might work. And of course, this is a role for civil society that, for a pragmatist framework, I think is really important. That's what we expect also of people, to give inputs, to mobilize the law for social purposes. Now, then, in terms of the content of the case, you can clearly see the uneasy relationship between the social and political purposes, climate change and environment purposes, and internal legal values. And in this case, the judges felt obliged to speak out primarily on those social and political issues of climate change. If you read the verdicts, there's a lot that's not very legal in it. That's interesting. But of course, in a legal context, you cannot really separate this from the core values of law itself. And as part of these values is, of course, also the institutional balance of powers that upholds the rule of law. This has two sides to it. On the one hand, we can say that there's direct consideration of the balance of powers, where you have the idea that if one central actor in law becomes too powerful, another actor needs to step in to counterbalance that. And sometimes that may indeed require that a judge intervenes in policy. But of course, you can also look at it from the other way. This was a very surprising move by a court, suddenly saying, well, I don't think government is up to the task of making policy here. I need to do something. And that also means that you cannot have a fixed model of the relationship between these powers. It's also a contextual judgment. So that's the one side. The other side is that the legitimacy of judicial decisions will derive from the way they balance different norms and purposes in the light of these legal ideals of legality and justice. So you need a certain justification of a decision in which the judge shows that these different concerns have been balanced. And it also requires being sensitive to what people in society expect from the judiciary and being able to explain why sometimes the solution must be to offer legal protection, or that it may sometimes be a solution that cannot be found in court. And of course, the court was very clear about that. They thought that they were very well placed to do this. Now, we'll see how this ends, because this spring there will the appeal of this case will be dealt with by the higher court, and we'll have to see whether it may not be overturned. And I think that what you see is that it's centered very much on the determination of the right policy to combat climate change, and neglected a little bit the legal values that were involved. And in this area, which is very much debated, I think in other countries too, it seems that giving an order to follow a particular climate change policy is actually making the judge a very clear political actor in this debate. And without a clear link to legal principles and values, giving such an order may come across, for some, and it did for some lawyers at least, as an arbitrary decision, which is of course not what judges want. So as a rule of law actor, I think the court needs to justify its decision rationally and in light of the broader purposes of law. And that means considering the legal elements in connection to the policy aspects, but not policy aspects by themselves. Now, in the Pragmatist framework I sketched, I think assessment of such a case will depend on consideration of its broader consequences. And although I really think it's a good thing that a civil society actor finds the way to court in order to raise the pressing environmental problem, pragmatically we need to consider the broader consequences of a judgment that intervenes in government policy. And ironically, in such a case, the broader consequences are actually the consequences for law and how the courts and how the judiciary and politics relate to each other, rather than the social consequences. So there are a lot of questions that you can ask here. How will this influence the role of the courts in other highly charged political issues? Will there be other cases in which they are then called upon to do these things? How will it influence government decision making? In what circumstances should we actually say that judicial restraint is maybe the better option? And I think the case is also a good illustration of the flexibility of broad standards, such as the duty of care in tort law, and seeing that you can actually mold them to fit your purposes, which is one reason why Dewey really liked standards, actually. But I think that's sometimes also a little bit problematic. And you might even say that it opens possibilities for arbitrary decision making by judges, and therefore maybe some people will call for more formal rules in this area. Now, I'm not against such flexible reasoning on the basis of standards, but I do think it requires very careful and rigorous justification of a decision. Now, one could interpret this court's decision as a problem-solving judgment in line with the pragmatist functional view of law. But I would argue that a good problem-solving judgment embeds a consideration of the problem in both the social-political context and in the central values and rule of law values of the legal order. And I think that connection was not made to the best of its ability here. Now, I realize that framing the issue of the rule of law in terms of one very specific case gives you a very specific and particular story and not a general assessment. But we've talked about this earlier. There's only so much that can be said about the values of the rule of law in the abstract. What I think it does do is open up space for discussion, also discussion between legal theorists such as myself and other lawyers and social theorists and sociologists who may have knowledge that is relevant for the working of the rule of law and the contextual arguments. And I hope that such a discussion on different considerations for when the rule of law should be interpreted in a certain way can actually be shared among us. Where I think that indeed the interplay between theory, things that I can offer, and practice, legal practice or more social practice, is also a crucial pragmatist concern that I'm very happy to be working on. And I thank you for your attention.